Special bench, my lord, to be presided over by my lord. The assignment order is also attached with the mentioning slip.
He find out from his lordship when he's sitting single or he's sitting with someone. Just part 37. Fix it in the next week someday.
So great.
Another prayer for inclusion in the list, new motion. New motion, prayer for inclusion.
New motion.
Here. New application.
Group 6.
Group 6. On contempt application. Madam.
Original side matter item number 1. Original side matter item number 1.
Yes, my lord, I am for the respondent. Appellate side.
Appellate side.
Not only
Original side.
not appellate side, original side.
Yes. Observe the affidavit. In this matter, I'm not seeking a stay, seeking any stay at present. It has to be heard by your lordships.
Who is for you? Are for the bank. You are for the bank. So any affidavit is to be filed. It's all there in
But I
the.
have annexed everything. All the pleadings I have annexed. So, if your lordships kindly fix a date of hearing, we can hear it out.
The learned advocate for the appellant and the
Item number 2.
My lord, I am for the appellant.
What I am for the respondent number 1.
If the respondent.
there's
My
more
lord-
than one respondent.
My lord, this was with regard to one of the orders with regard to payment of the petitioner, retiral dues of the petitioner. Now, my lord, so far my instruction goes, my lord, that payment has already been made. A report has been submitted before the single judge. And my lord, the petitioner is to take an exception to the report, if any. Now, my lord, at this stage, the matter is lying before the single judge. So, my lord, most probably I will not have to move the appeal. However, my lord, let me come back with instruction of my client. My lord will kindly keeps it next week.
What instruction you will take if they have already paid the dues?
My lord, I just want to take any instruction whether any all the payments have been made or anything else.
Even if not paid, it can be raised before the single judge. Where's the question of us doing anything now in this proceeding?
My lord will kindly gives me 1 week. My lord, let me come back.
What, madam? What? Why should we keep it pending unnecessarily?
My lord, because there are other
What
aspects.
is the order under challenge? Let's see.
My lord, the order under challenges, my lord, is dated 6th April 2026, my lord.
Yes, so what is wrong with this order? Tell us.
My lord, the order was passed directing the respondents to make all the payments. However, my lord, there was another aspect of the retirement benefits of the petitioner which was not taken into consideration and which was not adjudicated.
Which,
It's also pending that
which aspect?
my lord, the petitioner had claimed for provident fund dues, and at the same time, the petitioner has also claimed for pension. Now, my lord, these are contradictory claims. Now, my lord, on this basis, my lord, the petitioner had preferred two writ petitions. Two different writ petitions which
This
were
writ
taken.
petition is for pension or for provident?
My lord, this writ petition was originally for the retirement benefits, the provident fund. Later on, my lord, by way of a supplementary affidavit, the petitioner has sought to include the prayer of the pension also in this writ petition. However, my lord, there was another writ petition which the petitioner had preferred. The petitioner had withdrawn it on the, my lord, at the fear of being reprimanded by the honorable court. Since the court had taken a note of the issue that two separate claims, contradictory claims, cannot be raised by the same petitioner. Either the petitioner is entitled to pension or the provident fund. Yes.
So it will all, you can raise it before the writ court. Yes, take down. Heard the
My lord, I'm praying for a short passover, my lord.
why, sir?
My lord, Mr. Shaljish Dasgupta, my senior, is appearing on court number 16, my lord. Kindly give him short. We will.
You are the appellant.
Yes, ma'am.
Yes. My lord, kindly read the order, my lord, it will take some time. Because previously, my lord, when I appeared, my lord, there takes time. Always
Well, I'm not
facing
my lord.
difficulties, my lord. Can you see the last 2-3 orders, my lord?
Let's see. NCWA.
NCWA. Compassionate employment, my lord. My father was an employee. I made
It is regarding compassionate appointment.
yes. My father was
MMCC.
no. Father was an employee, and I have, my lord, applied for employment. They, my lord, conducted the medical, though I have the birth certificate. Their medical found me fit. Again, my lord, the second medical found me fit. Again, my lord, this one directed the Bardhaman Medical College, my lord, to assess my date of birth. There also I found fit. And accordingly, the trial court has directed them to accept that medical of the independent medical board and to consider the employment. This is the fact.
So there is no proof of date of birth.
No, if birth certificate is there, even then they have not accepted. Still, they have conducted the medical. In their medical, I found fit. Again, my lord, this honorable court directed, my lord, the Bardhaman Medical College Independent Medical Board.
So the medical board corroborates the date of birth claimed in the by virtue of the birth certificate.
Yes,
Same.
same. They have conducted the ossification test. Is this, my lord? There is a range. In their medical, independent medical, some range has been, my lord, considered by them that 35 to 40 years.
Correct. In the medical, it can't be a precise
Yes.
examination.
Now, my lord, if I accept the 35 years lower range, then I am qualified. If it is accepted the higher range,
But what is the occasion for them to doubt the legitimacy of the birth certificate?
no, there is no, my lord, nothing has been, my lord. They have said that the birth certificate is not believable.
Oh, then why the learned single judge directed for a medical test?
Maybe because they have conducted the medical. Since there is a birth certificate, even then they have conducted the medical, so the trial court has directed to.
Birth certificate is a more preferred date of birth.
Yes.
Why the
Yes, my lord. Can you see
assessment
page 57, my lord? Let them verify. If they have any doubt about my birth certificate, they can verify.
is why we are saying that that is the most preferred document.
Yes.
What is the date of the birth certificate?
Page 57, my lord.
57.
Yes. Of the stay application. 89. (1989) means now I am 37. And my lord, my father has died on, my lord, 2022.
It's not a contemporaneous document.
Certificate is there, my lord.
It is of 2013.
Yes. Death of my father. Father has died 2022.
No, but what is your date of birth?
My lord, it is written, my lord, 5th January 1989.
89.
Yes. Below 35 years at the time of death of my father.
Perhaps that's why they have not accepted the birth certificate. It is of a much later.
Even I will accept the medical conducted by my lord, the Bardhaman Medical College. Even then I am qualified.
Then we'll see. Let him be here.
But can you see the, my lord, order of the trial court?
No, we have understood. We want him to be here. We thought that perhaps your birth certificate was contemporaneous to your birth, but it is not. It is of decades later.
But they are not, my lord, on the point of birth certificate.
Let's see what
They are
it
on the
is.
point.
Whether
The
or
mid age has to be accepted.
so therefore there is an issue.
35 to 40. They are saying the mid age has to be accepted. My point, trial court also accepted that point. We have the revision of the court. Since the beneficial release of legislation or the beneficial clause of the
Beneficial, that is correct, but you have to be qualified. Qualification cannot be relaxed. So let him be here.
now the question is, they have urged that 35 their medical board, Bardhaman Medical College, both have point 35 40. If you accept the 35, then I am the below of quantum age. If you accept 50 years, then out of boundary. The trial court directed them to accept the lower range of the, because the 34 to 35 to 35 are entitled. So 35 is already there. That also accepted 35. Under the LCW up to 35, the male dependent is entitled for employment.
Yes, you are appearing.
Yes, I'm for the authority, Milord. Milord, here, Milord, the question is there that there are two medical reports, which one the court should follow. That's one point. But Milord, there is another point, which Milord, the Honorable Single Judge, while dealing with writ petition, Milord, did not, but rather could not, Milord, place any reliance on the record of the organization, which I have disclosed in the appeal. In the court below, I could not, Milord, disclose. We did not disclose the records of the authority, records of the petitioner, which were there in our custody. The date, the age of the persons who could be nominated, and every details which were there. That is Annexure C of my stay application.
These details were furnished by the employee.
Yes, at the time of his employment. So, the Honorable Single Judge could not place any reliance on, because these were absent in the court below. I have, in paragraph 4 of my stay application, Lordship would find, and this is the reason why, there was a prayer for dealing with these particular documents in an affidavit in opposition to the stay application, which they have never filed. Lordship had granted them. That is the reason why this opposition was filed. This particular pleading.
So filed in opposition.
Yes. Now, I will place the opposition as well. Kindly see paragraph 4 of my stay application. This is that apart from the medical certificate, that issue. The admitted position is that the father of the petitioner, late Doman Bhuya, died on 21st October 2022 during the course of his employment with the appellant petitioner number 1 organization. Consequent to his death, his legal heir, that is his wife, Purni Devi, submitted an application for employment to her son. That is the petitioner on 1st December 2022. Such application for employment was rejected by the appellant by a letter dated 2nd September 2023 on the ground that the petitioner was found to be overage as on the date of application. Such finding was based on the Form F submitted by Srimati Purnima Devi, who was the nominee of late Doman Bhuya. So the first rejection was based on this Form F submitted by the mother of the petitioner. A copy of the Form F and the service book records the late Doman Bhuya are annexed here to and collectively marked as Annexure C. These documents could not be disclosed before the Honorable Single Judge, since no opportunity was granted to the appellants for filing affidavit. It is due to this reason the petitioner claims leave to rely upon and refer to the relevant documents in support of their contention at time of hearing, if necessary. This is Annexure C. Now, that is at page 60 of the application, Milord. Now, although, Milord, I have said that this there was no opportunity to file affidavit opposition, that's why, but I don't say that, Milord, when I'm arguing, Milord. It's our fault. Opportunity, Milord, I have also not sought for any opportunity to file any affidavit in opposition. So, Milord, naturally, court will not, Milord, request me to file an affidavit if I don't want to. So, I don't say that now. I'm saying it was our mistake. We did not bring these records for the court below, and court did not see this. So kindly see page 60 is the Annexure C, which the mother of the petitioner, her himself, had filed before filed in our records. Now, Milord, in that page 61, Lordship would find the nominated person was particulars were provided.
The date, what is the date of this document?
The date of the deceased, Milord.
Page 61 is not legible.
64 is not legible. Better copy ache 64. The 64 is not legible, Lordship.
61.
61, Milord.
The date should be at 61.
Page says, Annexure C starts from page 60.
Yes.
60 starts from 60. Then, Milord, 61 has the declaration.
Yes.
And the declaration relating to the nomination. And my lord, 62 is the records.
Yes. And where the age or date of birth has been mentioned.
The lordship would find page 62 towards the bottom, the service from service records, Doman Bhutia, fathers and such, permanent address and such. Date of birth is 19 years as on 1st February 1990. Then, my lord, next page 63, Purnima Devi and the Mukesh Bhuya, who is the petitioner before your lordship. Their also date of birth are provided here. Okay,
And what is
63
the
is not legible, right?
upper age limit? What is the upper age limit?
21, my lord,
No, upper age limit for the purpose of compassionate appointment.
35 years.
35.
35. He was 8 years in 1992, according to the own declaration of the petitioner. Page 63. So in 1992, if somebody is 8 years, then my lord, during 2024, what would be his age?
Where are you reading? It's so
Page
illegible.
63 at the top. Purnima Devi, 21 years.
Yes.
Next is Mukesh Bhuya, 8 years. Mukesh Bhuya is the petitioner before your lordship. So by 2000, my lord, here at end, he is 16 years. Then 2024, rather 22, when his father died. So 22 years from 16, it would definitely be more than 35.
This is 8 years in which year? In the year 19.
This is 1992, my lord. My lord, in 1990, rather, my lord, page 62 refers to 1990. 1st February 1990. Date of appointment is 13 December
No,
1990.
at the top of that document, it says 6892.
Yeah, I mean, I take 1990 because my lord, date of appointment of the petitioner was 1990. So I will give relaxation of 2 more years. Even then, if he was in 2000, if he was 16, then in 2022, when the death occurred, then that he could not be less than 35. But these records were not there before the Honorable Supreme Judge.
And what is the date of application for his compassionate
So
appointment?
the first application was made by the mother of the petitioner in 2023. Sorry, that 1st December 2022. Then that was rejected in September 2023. Thereafter, my lord, in 2024, the fresh application was made. But interestingly, what happened after rejection of the appointment request of employment for the mother asked for correction of this report, saying no, my declaration was incorrect. It would be 6 years instead of 8 years, 5 years instead of 8 years.
Where is that?
Well, that I have pleaded. Kindly see paragraph 5 of my stay application.
No, where is our application?
That application, my lord, was in the writ petition itself. My lord, I'll show that.
Page 49.
Page 49 of the writ petition. It is after rejection of her own appointment on the age ground, she filed this approached authority with this request.
So her claim was rejected.
No,
Her
no.
claim was not, she withdrew.
No.
That she with
The application was made for employment in favor of the petition only.
that I'll
Now, my lord, here,
Please wait.
my lord,
Please.
kindly see page 40.
40?
47. I'll not make incorrect submissions. Kindly see. This application was made in 2022. Lordship would see at the bottom, my lord. In 22, my lord, somebody applies. Purnima Devi applies. He says
Referring to this 1/12/22 document.
1/22. At the bottom, she says, I request you to kindly consider my application for paying interest to my son, then I say you can't get it because your son was
She
of
is
age.
not claiming for herself. She's
No, herself. I said she made the application because at that point of time, probably, I don't know why the son did not apply. She applied. We rejected her application saying your son was overage according to our record.
There is already a rejection.
Yes. Then she wrote that letter.
Where is that rejection?
Kindly. Yes, the page 48. 48, the next page.
This is after this what happened? After
this 49, write to us saying it's a mistake in the record. My declaration was incorrect.
Oh. And then again you have rejected.
Then again she after this she applied again and I said it has then we got this procedure of appointment of medical. Yes, after that I again rejected.
Where is the second rejection?
There is a second rejection here. That
So according to you, it was rejected twice.
yes, but that page 74. No, not 74. I'll just finally page number what? Okay. I'll just give Lordship 1 minute. No, final rejection. Yes, 27 November 2024. 27 November 2024 was rejected again. Lordship put that probably will this P9, page 55. Yes, page 55. All along the mother is applying page 50. This is the second time after.
Can anyone read this?
That I myself that may I do one thing that I'll give a better copy.
It's impossible.
I am
How can you read it?
I am not being able to. I need a better copy. But may I? Better copy type copy
You have a better copy
Page 53, my lord.
of the same document.
It's not same copy. Based on this copy, my lord, they have rejected. Kindly see at bottom, my lord. They have conducted the medical. Age assessed between 35 to 40 years. This is their main ground.
This is not my main ground. My main ground is my record says 8 years.
Based on this, their own medical, they have rejected. Under the circumstances, your application providing employment to your nominated son, leave of death of such and such cannot be considered as per the component record. However, such and such. So 35 years is the criteria.
This second rejection is in context of which application? Is 49.
49. Yes.
This second rejection is impugned in the writ proceeding.
Yes.
How can we read this? How have you annexed it?
But I have annexed the writ petition. Look, they have annexed this document.
This is the impugned order and we can't read it.
No, actually, in my read application, it was fresh copy. Stay. That is not.
I have been. This is been served upon me. I have no other option. reply দিই তো আজকে সার্ভ করলো ফাইল করে সার্ভ করেছে কবে বললি না কেন হার্ডিং গুলো আজকে তো 13 জাজ কি তো প্রথমেই তোটা বলেই তো আমি তো ফাইল রিপ্লাই টু দিস
You have not taken MMCC.
No. Actually, as per their medical, I am entitled.
No, absolutely not. I am saying, but one more thing. Before Lordship, I have received the reply today, right now.
So in the writ petition, this was not put to challenge.
No, in the petition, they did not challenge the records. They asked for, my lord, I'm being led by Mr.
বলো আমি জানি না কি বলছো I don't know what it is.
But in the chain of event is that the mother applied to me saying, give my son the job. I write to him, your son.
No,
according to
what
my
we are
data-
asking you is that till date 29/23 remains unchallenged.
That first rejection, yes.
Yes.
It is unchallenged. Unchallenged, not only that, my lord, after that, when the second application came, that came with a prayer for correction in the records, which remained uncorrected. So that they also did not ask for correction of that record. So if that remains in my record, if the record still says 8 years,
Give us a better copy of this.
and my lord, I have to deal with the opposition which came today.
No, 14 তারিখে দিয়েছি on
No, no, in court you have filed today without the leave. It's late,
No, no.
belated 3 months.
I have sub advance copy.
Yeah, after 3
It's
months.
affirmation.
How will I presume that lordship will accept this?
You
This is-
take
the
this,
rejection
then
was in
CL will not
February.
even ever will file any opposition.
Application test দিতে হয় by the medical board
No,
conducted.
recording যাচ্ছি,
হ্যাঁ,
recording
recording
8 তারিখ, কেন তুই যাচ্ছিস?
Test দিতে হয়।
Anyway, you have to give us a better copy of that document. You have to give us a better copy of that document.
Better
copy?
copy maybe I am told a better copy may be given to us.
So that's not legible. How we will consider
Page 49.
page 55, page 55.
Legible, no? ওখানেও legible, এখানেও legible.
No, it's
দাদা একটা এটা
impossible to read. It's all black.
This portion is absolutely impossible. এটা তো right.
Top 4 lines are not at all visible.
এখন
না, না, এটা না, এটা তো আগে, এটা আজকে দিয়েছি।
এটা আজকে দিয়েছি পেজ 355 টা তো legible copy.
It is the impugned order which they have challenged, which they have to read petition.
But initial rejection is also under challenge.
In the writ proceeding,
Yes.
let us see.
অর্ডার দেওয়া হয়তো অর্ডারটা দেখে গেছে,
এখন রিটে চ্যালেঞ্জ করে
রিটে চ্যালেঞ্জ করেছে, কিন্তু
Written challenge করেছে।
অর্ডার
Yes.
Yes, come to page 40.
40.
Yes.
সেকেন্ড রিজেকশন P8
Page 41.
ফার্স্ট না
Yes.
মেডিকেল রিপোর্ট নিচে এসো।
The medical report, because based on the medical, they have rejected.
You said it is challenged. Where is
Medical
the
report and subsequent one.
You said that this is challenge 1/12/22.
No, the medical report and subsequent.
We asked about 1/12/22. That's not under challenge.
But here question is, my lord,
বলো
they have accepted
আমি যাচ্ছি
the sending by judicial order before the,
Now let's see the learned single.
that has not been challenged by them.
learned
Judicial order has not been challenged by them. How they can question this final order?
Let us see the learned single.
So kindly see the landed single bench order, my lord. First, my lord, can see page 68.
লাগবে ওই বাজে আমারটা নিয়ে নিও, আমি তোমাকে অ্যাসিস্ট করতে পারবো, তুমি এটা থেকে দেখো, আমি কিছু বলতেই পারবো আমার ওটা
Impugn order to the. What is it?
Oh, it is still pending.
My lord,
The writ petition is still pending.
no. My order has been passed. This is the initial order directing the authority,
It
the
is 26/25 is the earlier order.
it's the interim order
26th August, 2025.
Where is the final order?
My lord is annexing the memo, my lord.
Final order is the order
At top, my lord.
order impugned petition. That may Mr. Ghosh take over, my lord. He is reading me in the matter.
Yes, where is the memo? Give the memo.
He will also find from the stay at the, my lord, at top. Page 15, my lord, of the stay application. On this argument, my lord, they have advanced and accordingly, my lord, this court directed the Baltimore Medical College, the Indian Medical College to assess the date of birth.
No, but the issue is, without challenging that 22 order, how you can proceed?
And the interim order has been accepted by them. That's reached its finality.
That's
Now-
not the point. The point is, can you get any relief unless you challenge the earlier rejection order?
With the final order I have challenged. So final order is merged with the, my lord, the earlier order,
Which final order?
the final order of rejection. Because what happened in the court industry, I have
The final order is an appellate order.
no final order by
What doctrine of merger will apply in the administrative side? What are you saying?
but
There is
here,
the rejection, you have chosen not to challenge it.
but because new fresh cause of action arose,
How a fresh cause of action can arise?
the inner thing is, my lord, in the service record, all are filled up by them. I have already, father has already and put his application. This is filled up by them. Now, my lord, not legal vote. The legal vote was a 35 to 40. Now I have challenged that legal vote orders. Now, that order has also not been challenged by them.
The medical board was conducted on their own volition.
Yes, yes, one volition, my lord. After rejection, they could not have, my lord, they could not, my lord, conduct the medical examination. I can make a series of representation. Now they have accepted, my lord.
Milord, page 51 is Milord.
Kindly see, my lord. They are medical first, my lord, kindly come page 57. This is the medical board conducted by the Eastern Coalfield Limited. That is the authority, the appellant.
In terms of this
Page 57, kindly see.
Request is at page 51.
I can make a series of requests.
I'm saying request is at page 51.
Page 53, if your lordship kindly come.
Very
This is the medical board of Eastern Coalfield Limited.
Upper limit. So we just at the last end of the upper limit.
I am challenging this medical board's order. Yes.
It's a record হারিয়ে যাওয়ার কিছু নয় এই কেস রেকর্ড আমি প্রডিউস করেছি কোর্টে যদি ইন্টারচেঞ্জ ডেট উইথ দ্যাট আজকে সলভ করেছি ওকে কিন্তু কিচ্ছু বলে না। I don't know. Very good. He dealt with my
কি লিখেছে দে এখনো তো দেয়
period. Our record. Stay. Stay বেলা পরে আমি দিয়েছিলাম পড়ানো হয়ে যেত পড়ানো হয়ে অপরিচিত This is how we dealt with it.
You will just give us a fresh copy of that order.
No. That my lord, page 53, my lord. Page কত?
Give me a chance to file response to it. Kindly
53 or 55?
15, 55.
55.
55. 55.
Give because he has.
When you will give us?
My lord,
When you will give us?
tomorrow.
Whenever Lord.
সোমবার রাতে হলে
Keep it on Monday, Milord. I'll deal
Keep
with
it on Monday.
Monday আমি আসবো।
কবে আসবে বলো তুমি তুমি
Tell us, we are asking you.
Well, after two,
He will be here every day.
well, after,
I'm here every day. He has other commitments. Milord.
We know he has already informed us. That's why we are asking him.
well,
People will not say please.
after 2 weeks. my
I
lord.
say I can request. কবে আসবে তুমি
After 2 weeks. বললাম তো।
This after this matter
They will not. The best is birth certificate, best is matriculations, and all any other contemporary prior to the history of the prior to that of 2030.
Item number 74.
I don't know what.
Item number
I'm sorry.
The appeal is dismissed. Call the next.
72. Oh, 72. Sorry.
Item number 72.
আমরা এইদিকে আসি আমাদের ডিগ্রি হোল্ডার হয়ে গেছে আপনাদের দিকে দাঁড়ান দাঁড়ান পড়ে যাবেন দাঁড়ান স্যার স্যার দেখে স্যার আপনি আছেন 70 এখন চলবে আসুন না
আমাদের Without which, আমি তো হাসাহাসি চলছিলেন দেখেছে Without it, utmost. Mistake of the in the court of sport. Those are the kind of things. Mistake, when mistake on the part of the court, into the mistake in the on the part of court also. I think মানুষের তো ভুল হয়
আপনাকে বলাটাই ভুল করেছে বলেছে আপনি
kindly see the order. Learned counsel for the appellant has passed on this court a written instruction from the appellant that he would take out an appropriate legal application before the executing court and does not wish to pursue the present appeal. Page 24 of the petition, my lord. Page 24 of the petition. But the tin the other, my lord. Yes, sir.
How this bench can consider?
Lord. And my lord. Yes,
How this bench can consider?
yes, sir. Oh, this is before the judge. I thought bench.
When it was mentioned, it was not pointed out.
Why, I mean, the bench is not, recalling. It is recalling, my lord, if this, my lord, presiding judge is common.
If the other judge is not available, you are correct. If the other judge is available, then how we can, sir, proceed?
All right, yes, right. Whenever my lord sits with justice,
Actually, he is also in review. He is sitting in the division bench, so I'll have to take consent. If, let us give us a few days. We'll ask him and we'll see when it comes.
Okay.
Matters, the issue arises.
My lords, will be pleased to find from page 80 to 82.
It is the learned AGP.
Yes, my lord.
You have been terminated.
Yes. My lord, an order of termination. My lord, may I just indicate to my lords, my lord,
Briefly tell us what it is.
yes. My lord, just in the show, the block accounts manager on 7/8/2002. In a case, and the then show cause notice was issued on the March 2022. Then when I did show cause notice, I made the prayer for resumption of duty. Then it appears that in reply to the show cause, that will come. I am less charge, and I think allegation will against me is not correct. I was never placed under suspension.
You are a permanent employee.
Contractual.
Then how you can be placed under suspension?
No, I said, these are the scenarios. Now, my main point, Millard, which I had taken in the particular petition is that the salary of the appellant, it was withheld from 2022. Then, Millard, I have taken a particular, Millard, point that a contract of engagement of the petitioner was valid from 1st of July to 30th June 2022. 1st of July to 30th of June 2022. Now, a resolution was taken that is very important, that my lords may kindly consider this resolution at page 175.
You said what you were engaged as block?
Block accounts manager.
This is in which office?
Millard, this
Block office.
block office. Millard, this is under the block health and family welfare.
Yeah. Which document you want us to see?
Yes, Millard, your lordship may kindly consider this document, Millard, at page 175.
Sorry.
This is a resolution of the ninth meeting. This was taken on, my lord, 1st of June 2022. Now, your lordships will be pleased to find that this particular, my lord, decision, it was never served upon the appellant.
Since when were you discontinued?
I was discontinued from, my lord, just 1 second, my lord, everything is from March 2022.
Which day?
Date,
His arrest. Ninth of March.
date, 1st of May 2022. Right, so,
And the FIR is of which date?
my lord,
The FIR is
Right.
9th of March, 9/3/2022. He was arrested on,
9/3/22.
on 7/5/2022.
7th of September, I was arrested. I
September,
think
no, September, May you were arrested.
September.
No, 7/9/20.
7/5.
7/5. So after he was discontinued.
And then lordship, bail lordship I find is 13th of June, I think.
No, whatever it is, but he was arrested after he was discontinued. Because he was already discontinued on 1/5. That is what we have just been told.
Now, my lord, I kindly consider that there is an order of termination. This order of termination is dated 3/10/2023 at page 201. That my lords will be pleased to find from the first volume, page 201.
So what is the relevance of this 1/5/22? You said you were discontinued on one.
Kindly see the resolution, the purport of the resolution at page 175. For a
Yes.
second, my lord, for a second, my lord,
So you continue.
regarding misappropriation of fund of this particular person, and my lord, then my lord, the CMOH and the member secretary takes a decision not to release remuneration to the incumbent until final decision regarding service is taken by the HR advisory committee at page 175.
No, you gave us a date that you are discontinued on 1/5/22.
Yes, 1/5/22. Yes, that
So
is not on
from 1/5/22 you have not been working.
1/5/2022. I am not working.
Then why a termination was issued in October 23?
I cannot say that. I will be
No, we are
showing
just
more
trying to unravel the
I
sequence.
will be showing to my lords Milon more glaring features. Kindly see this order of termination. This was issued on 3/10/2023.
Yes, at page 201. Yes, you just told us.
Now, this particular order of termination also was not served upon the petitioner till the date of passing of the judgment by the learned single judge on 19th of March 2024. There was only a communication, or this was Millard handed over in the court when the order was passed. And I have taken a specific point also in my memorandum of appeal. My lord, one thing more I should indicate to my lord, there is an inquiry report at page 28. Page 28, there is an inquiry report. This inquiry report was submitted on 18/2/2022. Page 28 is the inquiry report. Now, my lord, my lords will be pleased to find that this inquiry report do not show that the appellant was called upon by the chairperson of the inquiry committee. এটা দেখাচ্ছি তো। Lord, one more document which I will be showing to my lords is page 201 to 202. This is the order of termination. What you will be pleased to find that in this order of termination of service, there is no indication that inquiry report was served. Then, my lord, there is a reference of only in the second page at 202, in the first paragraph, state level inquiry team submitted their report on 10/8/2023, which revealed several irregularities of Bipod Bhanjan Day in maintenance of the books of accounts, vouchers, etc. In related documents, found misappropriation of fund, transferring to own bank account and other suspicious bank account, transfer of salary after resignation, irregularities in Nishchoy payment, foregoing signature, etc. Miller, I have indicated that this particular report was never supplied to me. And whether this inquiry report has been submitted or not, Miller, they have filed an affidavit in opposition. That affidavit in opposition, my lords will be pleased to find. Just 1 second, Miller. Affidavit in opposition to koto pata ache bolte. Just 1 minute, Miller. This affidavit in opposition starts from page 206 to 217. The second volume. But I have checked up the affidavit in opposition, subject to correction of my lords, my lord. I must not say anything. I did not find that there is any statement that they served the inquiry report in the particular affidavit in opposition from page 206 to 217. Now, my lord,
There is no proceeding against you.
that's right. That's right. That is now, my lord, the last is that your lordship may kindly consider that.
But they gave you an opportunity to submit a show cause.
Yes. Now, kindly see page 151. This is also very relevant. Why I say, because they themselves say that he may be given assignment to any other place. Page 151. This is a letter written by the Chief Medical Officer of Health on 9th of March 2022, addressed to the Mission Director. In reference to above, the undersigned would like to inform you that a show cause letter is issued to Sri Bipod Bhanjan De, posted at Block Health and Family Welfare Office, by the office dated such and such, and FIR is lodged against him at different police station by memo dated 9th of March 2022. At the present circumstances, we are recommending and requesting you to remove Bipod Bhanjan De from his present place of posting and place him at a different district till the complaint is disposed of, as there is no vacancy in the post of BAM in Rampurhat. And the police complaint, Miller, I am being instructed to submit before your lordship that this is still pending. And my last point is that I suffer a prejudice for non-furnishing of the inquiry report because I could not disclose my defense. Excellent. No, this is a very, Lordship is well aware of this judgment. I need not.
Where is the resolution of the 13th meeting?
13 meeting. Okay. Page 180, 180.
You filed any amendment also before the writ court?
No, subject to correction.
So this is the only order you have challenged, which is at page,
Yes.
page 72A.
Yes. No, I have challenged the order, Millard, at page 80 to 82. That is the,
No, in the writ petition,
in the writ petition.
you have only challenged this order of 7/11/22. This 23 was not challenged by you.
So this was not within, it was not available, for which I could not challenge. That's the reason I told you, Lordship, that this order of termination, this was not was not in my possession. I got it at the date when the matter was disposed of.
But actually, it does not change the situation because you have not been working since long back, since May itself, May 22. They have
May
not been
22.
allowing you to resume duty. They have not been allowing you access to the office,
Yes.
and they have not been paying you any remuneration. So
Yes.
how this 23 order can create a cause of action to?
No, your Lordship may kindly consider that this order of termination dated 3/10/2023.
That remains unchallenged till date.
That was, I told you, Lordship Miller, and that also I have taken this part. I am grateful to my Lord Miller in the memorandum of appeal. Just
Yes.
kindly see. Just 1 second, Miller.
Oh, it was part of the report filed by them.
Yes. येटा देखिए मेमो memo of appeal.
So why didn't you seek liberty to assail this order rather than arguing the matter on merits? You should have sought a liberty to assail the order.
যশোর বলছে তাহলে তুমি লিবার্টি নিয়ে এটাকে করো এখন দিবে তাহলে তুই মেমোটা দেখে না কত পাতায় আছে একটু আমাকে হেল্প কর আচ্ছা the memorandum of appeal, it starts from page 86. Rather, Millard, the operative portion, Millard, kindly see the first ground at page 88. First ground. And a trial court failed to take into consideration that the order of termination dated 3/10/2023 passed by the Chief Medical Officer of Health and Secretary, District Health and Family Welfare, Rampura District, was not served till the date of passing of the order on 19th of March 2024.
19.3 is the order passed by
Passed
the
by the
single
Land
judge. On that day itself, report was filed.
Yes. And also, I kindly see also, Millard, the grounds at 3, 4, 3, 4, 5, 6. And 9. 3, 4, 5, 6, and 9.
3, 4.
3, ground number 3, the for that the Learned Trial Court failed to take into consideration that no opportunity of hearing was given to the appellant in the meeting held on 1/6/2022, 19/10/2022, and 4/11/2022. In ground 4, the Learned Trial Court failed to take into consideration that the inquiry report was submitted on 18/2/2022 by the appellant and the inquiry committee along with the members of the inquiry committee and addressed to the Chief Medical Officer of Health and Secretary District Health and Family Welfare Samiti Rampurhat District. An appellant was not called upon by the chairperson of the inquiry committee. Kindly also see
Yes. What is the relief that you will get now? That we are trying to. What relief can you get? You are a contractual employee. Since May 22, you are not working. In October 23, they pass an order of termination.
Yes.
So when you have not worked since May 22, there is no question of payment of any remuneration.
Since an order of termination was issued, I cannot work.
No, you are not working since May 22.
May 2022, but
They have
now
stopped your remuneration, they have stopped your entry in the office, they have stopped taking work from you.
yes.
And you have continued like that. In October 23, they pass an order that you are guilty of such and such misappropriation and therefore you are terminated.
Millard, if any proceeding in whatever form it is being instituted against a person concerned who is working, be it contractual or Millard a substantive post holder, but Millard the well settled principles which my lords have laid down, that Millard the particular Millard parameters within which the particular there should be conclusion of proceeding, that should be Millard held in a reasonable manner. But in the present case, Millard, it seems Millard, subject to correction of my lords, there was no adherence to that.
No, see the
They
West
think
Bengal
They just stop.
West Bengal classification control appeal rule does not apply to you.
No, not
So
applicable.
there is no question of following that procedure.
Yes,
Yes, there is a requirement of proceeding in accordance with principles of natural justice,
yes.
giving you a fair opportunity, whatever may be your status.
Right.
To that extent, we are with you. But then you cannot take anything back in the office.
No, I am only submitting, at this stage, Millard, if my lord's Millard confirms the order of the learned single judge, it will be nothing but Millard giving a stamp on a particular proceeding, Millard, which was not born, Millard, or which was not
Which
conducted.
Prior, so just give us a minute.
Yes, I'm sorry.
Prior to this October 23 order, was he afforded any opportunity?
Yes, Lordship. Lordship, when it comes to page 33 of the
Page?
volume 1.
No,
Page
that we have seen. That's why we are asking you.
That is his reply.
That we have seen. That is why we are asking you. So you need not have passed that order in October. He was out.
What if we- I-
Now, when you visit him with a stigma by passing an order in October 23, which is not preceded by an immediate, because you are taking into consideration some resolution of November 22.
Yes.
In the order of October 23, you are taking into consideration some resolution of November 22.
So the resolutions of the
Please see page 201. Whereas as per resolution taken at 13th HR Advisory Committee held on 22,
first June,
not to allow access, that's all right.
first June 22, thereafter.
So many orders have been taken into consideration after this opportunity of 33, which you are trying to show at 33.
Yes.
So how do you sustain that? That we are saying. Whether he goes back in office or not is a different thing. So what we think we should, what we will say is that he will not be visited with any stigma by virtue of this order of 3/10/23. It will not come in the way. Already there is a criminal case pending. If that is to have any consequence, that may have a consequence whatsoever. Contractual, he surely cannot be put back, but he will not be visited with any stigma on the ground of this order. So if there is an avenue, otherwise this will not stand in your way. Yes, take down.
Do not take me amiss.
Yes.
That the instruction is kindly take me back with no stigma.
No, back.
No, I say this is not my subject.
Very well. Yes.
No back wages.
Item number 1 and 2.
My
Lord, I am for the petitioner.
lord, I am for the respondent, my lord.
Appellant, my lord.
It should be FMA, not MAT. Number is correct. Oh. No. So this, just a minute. MAT was on the list. Yesterday, what happened? MAT 1743 was listed.
FMA 1743.
File of different case was given and we have passed the order. That is why we have listed it after it was pointed out to us in the evening that the file was not available. So we have not signed that order because it was brought to our notice. So we will just record an order in this case that it was recorded in a wrong file. It was recorded in which file? FMA.
We all are human beings.
So your lordship could not even go through the experiment order whether.
Anyway, this matter was listed yesterday. MAT 1743 of 2020.
But item number 3 would.
No, no, no.
Item number 3.
Lordship, we are for the applicant, led by Mr. Shamim Ahmed. The learned senior counsel is currently out of station due to some personal urgency. As such, I am praying for an accommodation for today.
State list after
Applicant.
Item number 4.
4 to 8.
4 to 8 is an joint application, I believe, by the petitioner. My lord, I am representing the opposite party number 2 in item number 7.
who is the opposite party? Private respondent.
Private is facto complainant.
Supplementary also yes. तभी तो
My lord, I am being led by a senior. My lord, I think he's engaged.
Lordship, Lordship was pleased to hear me briefly last time. My lord, this has been assigned before your lordships. This is offense. Offense principally is under the West Bengal Financial Depositors Act, along with 420, 406 of the IPC. My lord, the petitioner before your lordship was a juvenile at the time. Petitioner's case before your lordship is that he was a juvenile at the time when the offense was perpetrated. Offense is alleged against his parents and others who were adults at that time. Now, along with them, the petitioner was also implicated in the FIR. Not knowing, probably the de facto complainant at that point of time did not know that by the time he had during the transaction, which is of 2011 and ending in 2018, the petitioner was a minor. He was born in 2001, October 2001. Now, the petitioner moved a petition under section 482 of the CRPC before this honorable court, then before the bench presided by Honorable Justice I.P. Mukherjee. His lordship was pleased to hold certain, my lord, I will read that order for your lordships. His lordship was, their lordships, both the honorable judges in the bench passed conjoint orders that they held that a peculiar circumstance in this case is this, that the offense was of 2011. Perpetratedly for an investment was invited by so-called investment was invited by the parents of the petitioner along with others. And for that investment, in lieu of that investment, certain money was paid and it was supposed to be returned. In 2011, it was paid and the amount was supposed to be returned in 2018. In the meantime, interest was supposed to be paid. Interest was paid, that is the admitted case in the FIR. Interest was paid, but when the principal amount was to be returned, the principal amount was not returned. That was the date was in 31st March 2018, the subject date. Both these dates, during both these dates at the time of
date is March
2018, and I am born in October 2001. Now, my lord, what has happened is that in the meantime, in this entire period, I was a juvenile. Be that as it may, their lordships held a point of contention was raised on behalf of the de facto complainant when the matter was being moved before this honorable court, that this is a continuing offense. Now, let's perpetrate concept of continuing offense. Why it is continuing offense? According to them, that the money has not been returned. So even after March 2018, it continued. But my lord, it would be a complete, if I may say so with all humility, it would be a completely wrong interpretation, because even if it is a continuing offense, it continues. The principal offense is perpetrated by 2018. Even if it continues, if the principal offense cannot be accounted on the petitioner for juvenility, merely it continues for non-payment cannot be accounted for the petition. Therefore, thereby their lordships were pleased to hold that two parts. One is that there is a specific paragraph to the effect that it prima facie appears that the petitioner was a juvenile when the offense was perpetrated. The Honorable Division Bench held that. Be that as it may, because this continuing offense part was taken as by the de facto complainant, according to Section 9, my lord is aware, Section 9 of the Juvenile Justice Act, whenever a point of juvenility is raised, at any stage before any court, an inquiry has to be held before query the offense whether the particular accused was a juvenile at the time of perpetration of the offense. That inquiry was left to the learned court below. The learned court below was directed to either decide, in the meantime, to decide on the bail application of the petitioner. Petitioner was granted bail pending the inquiry. Now, in the order, in the impugned order, in spite of all the observations of this Honorable Court, which I will place before your lordship, the learned court below came to a strange finding. He admitted that the petitioner was a juvenile both in 2011 and in 2018. But he says at the line that at the time of registration of the case, the petitioner had become adult. The case was registered in 2020. By that time, the petitioner had become an adult. As a result, petitioner cannot avoid responsibility. This is what his finding is. But this finding is palpably, with all humility I say, it is palpably wrong, because even the concept of continuing offense cannot be related to the date of registration of the case if the principal offense is not made out against the petitioner. Somebody perpetrates, it continues against him. I perpetrate an offense against my brother appearing for the other side. I make inducement on him. He pays money to me. I am capable of transacting in that.
Claimed by you.
What is the date of birth you claim? Date 2nd October 2001. My birth certificate and municipal birth certificate is at page 70. My school leaving certificate is at page 67 and 68. But both these documents are accepted under the juvenile justice rules as documents of unimpeachable character.
An issue is not about any the determination of age. The issue is whether after such a determination, whether you are liable to be an accused or not.
Yes.
That is the only thing.
Yes. And that is where the learned court below created, if I may say so, or in one line, he decided that the petitioner was, if I may read that particular portion, it is crystal clear. When the complainant invested the amount in the project of the accused person in the year 2011, at that relevant point of time, the present accused petitioner was a juvenile. But at the very point of time, the present accused was only member of the said project, and he had no active role to play for the offense, because 2011, the petitioner was 10 years old. For the offense committed by the co-accused persons along with this accused. This is again a wrong finding. When the case was initiated, now he relates it to the date of initiation of the case, which is again wrong, my lord. When the case was initiated at the very point of time, the accused was not a juvenile. As I have already stated above, and he was aware about the fate of the offense, in spite of the same, this accused also did not return the alleged amount to be paid to the complainant. Now, if the learned court's view is that in both the tranches, the petitioner was a juvenile, then the responsibility of returning the money also does not rest on the petitioner. He has related the case to the time when the case was initiated. Case initiation is a reporting of the crime which has already taken place. The crime which had taken place during the juvenility of the petitioner. Well, this was the finding of the court, and as a result of which the court came to a finding that be that as it may, the documents available on record speaks that the accused in the year 2018, again, my lord, 2018 was a juvenile in conflict with law, but he had knowledge and he had knowledge about the consequence of the offense. The whole purpose of the Juvenile Justice Act is that no knowledge or consequence can be attributed against a juvenile.
We have not seen things. We are only proceeding on what you submitted.
My lord.
The coordinate bench said to determine the age. Now, if the limited remit was to determine an age, where is the issue of responsibility arising on account of such an order being passed? The court was only directed to determine the age. Age has been determined. So that issue is over now. Now, whether you will be responsible or not, that is a different thing.
If the age is determined and I am held to be a juvenile, no proceeding can continue against me.
That's a different issue.
The proceeding has been maintained by the learned court below. After determining my age.
So there are two separate orders or there is a combined order?
In one order.
Let's see the order.
Finally, my lord, absolutely at the last certified copy bunch, 24th January 2023 order.
Lord, may I just indicate, my lord, before your lordship sees the order, my lord, I am for the, my lord, the victim. My lord, there was a, my lord, the state was, my lord, one copy.
Then why it is coming here?
My lord, 2 copies were filed. Yes, what was always pending before the division bench, my lord.
May I just indicate, just take 2 minutes to summarize.
Yes, please tell us.
My lord, my lord, I was one of the complainants. 2 crores went out of my pocket. My husband, me and my son collectively, my lord, we lost about 40 crores. This way, my lord, there are at least 15 to 16 matters where charge sheets have been filed. And initially the complaint was only under, my lord, 420, cheating. My lord, then, my lord, when these police authorities were investigating, my lord, they found that there are so many complainants against the same group, accused persons. That is when, my lord, the Depositors Act was, my lord, applied. And charge sheet also, my lord, has been filed under the Depositors Act. Now, under the Depositors Act, if the person who's accepting deposit doesn't repay, my lord, there's a duty upon the authorities to trace the money. Now, money travels, my lord, from the depositor to the next depositor to the next depositor, and the authorities are duty bound to chase, my lord, till the very end until the money is found. Now, my lord, investigation reveals
that we appreciate what you're saying, but that is a different issue.
No, my lord, may I just point out?
One is the liability to refund an amount, another is whether he can be made an accused when he is still a minor. These two are two different.
After he's turned major,
he is not an accused. Once he has become a major, they may trace him if there is a provision. Take the money from him.
Charge sheets have a finding that a lot of money has gone into his bank account.
Maybe.
Which he has as a major. And this money is being further, my lord, siphoned.
Is whether he will be made, the investigation tomorrow may lead to this money being found somewhere else. They will not become accused.
Certainly, my lord. But if somebody...
The money may be retrieved, but they will not become an accused.
Understandable. If whether this person has played a role in, my lord, concealing the money,
that is not the issue. Whether this person was a juvenile or not, that is the only issue.
My lord, the act, with respect, my lord, subject to correction, my lord, the act,
the submission which is being made by my learned friend is not there in the charge sheet.
The act, may I just see? No, I will show the charge sheet also. In fact, in my case, my lord, another case's charge sheet has been.
We are not on charge sheet. See, we cannot open the entire case here. The limited issue is there was a remit for determination of an age.
Yes,
if while determining an age, the court has held that he is also an accused.
Yes.
Then that is the only issue.
That is the issue. So, my lord, there was a direction upon the state.
Based on a date of registration of FIR, because as far as we know, subject to what you may say or show, we don't know.
FIR has been registered after
the juvenility has also always to be considered with reference to the offence. That is a settled law, and
yes,
I don't think you will come with anything on other than that.
Not at all.
So,
my lord, all I'm saying
of juvenility always has to be considered with reference to the offence, date of offence.
So, my lord, there was a finding of the High Court that part of the offence has occurred when the person was a minor, namely money being given by me. Another part of the offence has been committed by him after he's become a major.
No.
That is,
please give us. See, his date of birth is 2/10/2001.
Yes, my lord.
The deposits are in 2011. what is the date of maturity?
my lord, I believe my friend my lord is referring to my lord a different item 5.
I have to start
Four.
with the first case.
Very
What
well.
in item number 7?
Item 7, my lord, in all these matters there was a direction upon the state to file a report. My lord, I do not
For the state.
my lord, I don't believe my lord the state has filed a report till date. That's what I wanted to bring to your lordship's notice.
Who
Because the
is for-
report will show the role of the
Who is for the state?
Mr. Pawan Gupta, I heard that Mr. Pawan Gupta.
order nikalo. The
That
chief
is good to know. Where is he?
the chief
You are led by him. That is good to know. But where is he?
There was no direction for the state to file it.
Yes. So you have filed in the others where there is a direction.
Oh, there's no there,
Order is there.
my lord, lawyers for the state have changed since. May I just pray, my lord?
He is saying in item 4 there is no direction. So in the other cases where there is a direction, we have already filed.
No, none of the.
Then there is none of the matter there is a direction.
I'll just check it.
So before checking, you are making the submission. Before going through the brief, you are making a submission. Wonderful submission.
That's right. But no, no.
Off the cuff, you.
There is a direction for the state to file it.
See, change of lawyer will not change the record.
Yes.
If there is an order, there is an order. Lawyers will come and go from the state side.
My lord, 1 minute.
Yes.
In respect of the case, my learned friend is appearing. The transaction is of 2015, redeemable in 2008. 31st March 2018 was redeemable, and investment was of 2nd March 2008. Right? Both in both these states again.
My lord, may I just, my lord, I must apologize. I stand corrected. The direction to file a report, my lord, was in a connected matter. My lord, where the parents, my lord, were involved. There, my lord, a report, in fact, has been filed by the state showing 997 crores, my lord, worth of a scam, where, my lord, the role of each of the accused persons, including the petitioner here, my lord. So, my lord, may I, my lord, only pray, my lord, I may be given a chance to put in my opposition, my lord, to this application, so that, my lord, I could bring on record those necessary things. Because in that matter, my lord, after 3 years in custody, the father was granted bail. One of the conditions was that he will not interfere with the recovery exercise.
But they just appeared 2 days. You have just appeared. Oh, your OP number 2.
Yes, my lord.
You have just appeared 2 dates back.
Yes, my lord, yes, in this matter, but my lord, in a connected matter, my lord, because there's a, my lord,
In this means there are 5 matters.
these are, my lord, I am in item number 7.
Only.
Only item number 7. In so far as the other items are concerned, I have represented.
We have taken up 4, then why are you appearing? Who is appearing for OP number 2 in 4?
I'm sorry, my lord, the list shows 4 to 8. The what?
So we'll go one by one. We can't have all the matters together. So there is no appearance in 4. So yes, you, Mr. There was a direction to the investigating officer to intimate the opposite party number 2. What have you done?
Even we have served one.
No, that has failed repeatedly. Then the court directed.
Again, we have taken the.
No, the court directed the investigating officer. What steps you have taken? So this order is there in all the cases. And only in 7 there is a representation of
Yes,
OP number.
but we also, my lord, haven't been intimated by the state.
Anyway, if you are here, then
Yes,
that is
my lord, in 7
so 4, 5, 6, and 8. There is nobody to appear.
appears so, my lord.
And in all the cases, there is an order of to the investigating officer. Can you please tell us the date of the orders?
20th February 2024.
Last order of service is rendered on 20th February 2024, as pointed out.
Investigating officer to intimate the opposite party number 2. Same order in all the cases. Yes, you tell us what steps you have taken. February 24. This matters are otherwise. Why these matters have come up before a division bench?
Lordship, this was enlisted under the Ponzi heading. Honorable Justice Rajeshi Bharadwaj presiding bench was taking the determination. His Lordship thereafter, my lord, it has been assigned.
Not Ponzi matters go before a division
Before
bench,
division.
notwithstanding, my lord, the nature of the application.
So that is why, my lord, the previous application also was taken by the division.
So 4, 5, 6, and 8. In serial 4, 5, 6, and 8.
Yes, it is in appearance. My lord, I am filing the affidavits of service in all these matters.
Date of service taken on record.
The age, my lord, is not in dispute, at least insofar as I am concerned. My lord,
We have understood. We have understood. Therefore, we are saying once that was the only limited remit of the division bench.
that is all.
Where was the question of going into anything else at the
Only seeking that once it is decided, sent to the Juvenile Justice Board, then it will be appropriately dealt.
No, that perhaps, my lord, is something that I would object to
We'll
because
see. We have understood the profile of the matter. We'll see what.
very grateful. My lord.
I bought it. Item number 9.
I'm for the state, my lord. This is the we started. Yes, yes. Place is next week. Any day or land place is case, I shall place it next week or my learned friend. I'm received the bill yesterday just from the state. Or my Lord,
I make a very short submission subject to my Lord's pleasure.
I will give in reply next week.
No, only thing, my Lord, production of records. I'll be praying for that.
Which one?
My Lord, it's a selection process of 1998 constables, 620 constables.
Yes.
Now, my Lord, the tribunal was moved. The tribunal passed an order directing that they should produce the records.
Yes. Yes.
They filed a supplementary affidavit,
Yes.
but did not produce the relevant records. Now, my Lord, Lordship will kindly see the order passed by the learned tribunal. That is, my Lord, page 51.
OA number?
My Lord, 1675/98
1675/98
of 98.
And what is OA 1818 of 2005?
11. 98 file
My
2000.
Lord, 1675/98 is the relevant one. There may have been other matters connected. Now, my Lord, here, my Lord,
Which page, sir?
page 51.
This is the order impugned.
No, this is not the order impugned. My Lord, the tribunal directed them to produce the records before the tribunal relating to the selection process. Lordship sees the language, my Lord. Respondent authority is also directed to produce the relevant papers relating to the selection process in the connected matter by the next date positively. Then, my Lord, the next page. The learned advocates representing the parties are present, hearing the parties. Supplementary reply matter stands for hearing in presence of both sides. Supplementary reply, if any, has to be filed within a period of 6 weeks. Giving a copy of the same, petitioner shall file rejoinder within the next. Then, my Lord, next page, my Lord, page 53. Upon prayer of the state respondent, they were granted leave to file supplementary reply, annexing certain necessary
Documents.
Totally. There is something wrong. None of the pages are telling. We don't know what you are reading. 53.
Order dated 3/12/2000, 1998. 2008.
We are considering COST 9 of 2000.
Yes, my Lord. COST 9.
9 of 2012.
This is a 9 of 11.
Original case 1998.
No, 9 of 2012.
No, original case
1998.
1998.
No, cannot 12.
Original case number OA
The
16
first title is Basudev Chakraborty and another.
DK Chakraborty and Jidas.
But COST 911, it is 912.
K. Roy and
My Lord,
another.
there were 13 applicants before the learned tribunal. After the order was passed dismissing
Here,
the
my lord,
application,
JOA number.
after the application was passed, কপিটা কি ঠিক গেছে জজ সাহেবের কাছে?
912 for this 911.
Something terribly wrong.
আমাকে দিন, আমি দেখে দিচ্ছি।
This is a tally this with the file. We have the file of COST 9 of 2012. On the list, there is COST 9 of 2011.
Yes.
That's why it's not that.
This is another file.
Cover is one and
We were wondering where you are reading. We can't find anything.
আরে হ্যাঁ তো 11ই তো হবে। 12 তো ভুল করে জজ সাহেবের কাছে চলে গেছে। At one stage, court was in such a situation, we didn't have the learned judges. That's why these matters remained pending. People lost interest, and that was the situation.
So your matter is not.
No, that's not the correct
We
file.
don't have the file. So what to do? We can't even record an order. Tomorrow, get the file. Have you understood what is the problem?
Joseph Kibble.
Have you understood what is the problem? No, they have given a correct number. They have sent the wrong file. How they have given a wrong number? Yes, if they want 2011, why they have sent 2012 file? How they have given a wrong number? The department has not given the correct file. In that, if it is on the list.
My lord, I am appearing for the petitioner in that matter.
Or in the 11 matter.
Only the file has to be brought. That's
No, the list has to be corrected. A file has to be brought. Yes.
file has to be brought.
Get the correct file. Get the 2011 file. Now you know you have to do something within a week.
Yes.
Now don't ask for an adjournment.
No,
Yes.
next week, any day,
Yes.
any day.
Give him a copy.
They have the copy.
They have only 11 has been served. Only 11.
Get the file of COSC 9 of 2011.
And
It will come on Thursday.
Thursday.
My lord, instead of Thursday, let it be next week, my lord.
All right, next Thursday. Thursday after that.
And date ta koto? Because I'll be.
And list this matter also. Why this whole matter is pending? Put it on the list next Thursday. COSC 9 of 2012.
No, they won't have noticed, my lord. It's my matter. The name.
That will list anyway. If they
No, we have to give them a copy and serve a copy and give it.
You are appearing in 12 also.
That matter, my lord, because that name.
For that case also you are appearing.
Yes.
So that will also come on next Thursday.
They have 11 only served.
Are Baba bolchi to.
Sir, give him a copy. That matter will also come on the next Thursday. Both matters you list. Yes. 11 and 12. 11 and 12.
Date.
9 of 11 and 9 of 12. Both.
9 10, 9 10, 9 10.
At least we have got some old matters. We have...
GP office, please.
GP office.
All right, call the next.
GP office. 9 10.
Copy date.
Number
Copy.
10.
I am appearing for the petition.
I'm grateful.
Lord, there was a direction, my lord. The state respondents wanted to produce the records in connection with the disciplinary proceeding.
Yes, we were informed that she has received yesterday.
They've sent a photocopy, Lordship, if you Lordship so desires. They've sent the entire records of the proceedings for the right. Lordship will kindly come to.
You are the staff nurse or you are the husband?
No,
I'm the
husband of the staff nurse.
He has let it out to you.
No, I wrote a letter in favor of my wife. My lord, the letter was written by me. It was, my lord, used as an
You let
exhibit.
it out to her.
Rent receipts have been
Yes,
issued by.
yes.
You let it out to her.
Yes, yes. It was used as an exhibit, my lord.
So we wanted to see whether in that case your role was examined or not.
That, my lord, from the records, my lord, it has to be ascertained, my lord.
Lord,
But it was used as an exhibit,
The
my
rent
lord.
receipt is an exhibit,
No,
Lord.
that's not the point. The point is there are two different proceedings.
Yes.
If his role has already been examined in an earlier proceeding and there is some finding, whether a finding to the contrary can be recorded today, that is why we wanted to see what happened in that, because the nature of allegation is such that it overlaps. If I remember correctly, that is why we wanted the record.
That is why, my lord, your lordship directed the state to produce that records in connection with the
So
discipline.
why don't you, both of you, examine the records and tell us if there is any finding in this regard, otherwise we'll proceed.
Very good.
Lordship. I'll give him a copy.
My lord, kindly give me a week's time, my lord.
All right, the learned AG
Grateful, man.
Deeply obliged.
Item 11,
My lord, I am for the petitioner, my lord. My lord, on the last occasion, my lord, Lordship was pleased to grant me liberty to file a supplementary affidavit, my lord, enclosing the original application filed before the tribunal. Like to the-
Give a copy
My lord, I have served, my lord.
Lordship.
so we can proceed. Yes, what is the tribunal's order which is before us?
Now, my lord, regarding the, my lord, recruitment of West Bengal, my lord, next year, my lord, West Bengal Police Recruitment Board, my lord. Now, my lord, on, my lord,
Yes, we have asked him. He has found a way. What is the date of interview?
annexure, my lord, there
What is the date of interview?
the date of interview was, my lord, 9th September 2022. My lord, annexure R5 of their affidavit in opposition. My lord, on that date, my lord, I have filed, my lord, my caste certificate, but my lord, on that date, my lord,
What is OBCB? What is the meaning of OBCB?
caste certificate, there is no caste certificate.
Huh?
Caste certificate.
No, it says it has to be revalidated. Why it has to be revalidated? No, if there is any,
It's a specific instruction in the advertisement regarding revalidation, Lordship.
no, we find that revalidation is required of certificates which are claiming a reservation under EWC. But this OBC, they want a revalidated.
Check it up, Lordship.
So what is OBCB? I'm trying to understand for my knowledge. I don't know.
Chip subject to correction.
No. The categorization is OBC, OBCA, and OBCB.
Yes, sir.
So why A and B are different from OBC?
That is only depend on caste, my lord.
No, Lordship. Maybe.
No, but then if
Lordship,
it is
maybe the geographical residence. I
no,
think
not maybe. I want to know what it is. Can you please show me?
I'll check. I'll check it. I'll have to actually আপনার কাছে জানতে জানেন না?
I have seen EC. I have understood what EC is now.
I went through the circular one day, but OBC A and B, what is A and B?
No, OBC A, OBC B, সেটা।
Because OBC is OBC, why A and B is categorized? And what is the basis for this classification? Why revalidation of an OBC certificate is required?
West Bengal.
How his status will change over time that he requires a revalidation. That's why we want to know what is OBCB. It is on some criteria or
Lordship. I'll just. Totally the guy. It keeps on going off. Lordship, according to the net, Lordship, OBCB represents communities that have advanced slightly more in education and social standing. They are allocated a smaller reservation percentage. In specific castes under each block, their respective quotas may vary strictly by state, as the central government uniformly classifies all groups under single category, because Lordship sees the certificate, but I think I should check it up, because Lordship ordinarily resides in Malda, because there are certain communities, I mean, they get a reservation for a particular district.
so from what I could gather is that they are not OBC because they are perhaps that community is advanced more.
One district and another. That is why they
Therefore, there is a smaller allocation of reservation
there is
percentage.
smaller allocation of reservation, and the question of this revalidation might come up.
Why? Why revalidation?
See, it's the, if your Lordship comes to page 37, this is Lordship ordinarily resides in the Malda district. I mean, whether this is relating, because there are
So
certain
this status is linked to domicile
maybe Lordship. Let me check.
or geographical.
Because this is why there's a great the ordinarily resides in the Malda district of West Bengal has been given in bold. So there is I think it's best to find it out, Lordship, because that is our assumption. We shouldn't.
Because he has given a certificate of 2015.
Yes.
And his interview was in September 22.
And
on the date of interview, he did not produce a revalidated one. That is the allegation against.
The allegation. And the advertisement requires all candidates to produce a revalidated. It's right from that stage they know that.
No, that means that means that OBC based B status is variable.
Lordship, this is with experience.
Because if it is variable, then there may be an occasion. Otherwise,
I am relying on judgment, my lord.
No, creamy. Oh, this is about. Yes, Lordship, Lordship, I'm handing over the updated. This is regarding the creamy layer. The validation
NCL is different thing. Non-creamy layer certificate is a different thing.
This is what he's giving. Lordship, let me check with the
OBCB is
competent. These are the guidelines I'm handing over, Lordship. But let me check, Lordship. But
please tell us what is the OBCB.
I'll check, because I had an.
He will have his case. Which judgment you are relying on?
2016 4 SCC 754.
Party's name?
Lord Ram Kumar.
Gijraria.
Yes.
That's what we know. You will rely on that. Let us see if it is variable. If it is not variable, then maybe Ram Kumar Gujraria will be available to you. The learned AGP submits that.
District and not in another. Malda, the giant community was a reserve.
So let us know. That's why we are saying.
Because there is a it probably relating to domicile.
So therefore, let us know. Otherwise, he is relying on the judgment. The apex court says it is a status acquired by birth, merely certified.
Yes.
So a certification, even if it is later, that will hardly matter.
That is also OBC category, my lord. That's it is.
Yes, sir, we agree with what you are saying. We want to know why this OBC, they want a revalidation.
Next date.
No, I'm looking for this number 4.
Give it to.
This for the, none appears for the.
Item number 13.
My lord, 13, 14, 15, 16. All my lord civil and same matters. And not only that, it is a very old matter, but the brief is quite heavy. Your lord.
Right.
Yes, quite bulky. So my lord, this Thursday, or if your lordship kindly, my lord, accommodate us, maybe at 2 o'clock or at 3 o'clock.
Lordship, I believe it.
You are ready?
I'll get back.
No adjournment is required.
No, Lordship. This is a review, Lordship, is fine.
Anyway, whatever it is. So Thursday, just see what Thursday we have free at 2 p.m.
দুটো আছে দেখুন না তিনটেই দেখুন It's very difficult to my lord get a lady agreeing to a.
I can't disagree with that.